Yes, Mr. Bates.
My Lords, my Lady, before turning to the two grounds of appeal, I'd like to make two overarching points to perhaps set some of the background of where I'll be going in my hour and a half. The first of my background points, or overarching points, is to take you back to the start of this case. And if I can trouble you to turn up...
Sorry, could you just say it again? I was flicking my paper.
Sorry, not at all. I'd like to make two overarching points to hopefully inform where I'm going in the rest of my hour and a half, or hour and 28 minutes as it now is. The first of my overarching points is to take you back to the beginning of this case, back to page 209 of the core bundle, if I may. And what you should have at 209 is the covering letter that accompanied the notice seeking possession in this case. And you'll see that initially it was Croydon's position that it was changes introduced by the Localism Act 2011, which had somehow changed the position as regards fixed-term secure tenancies. And it was the 2011 Act that was the reason why the previous understanding as to how fixed-term tenancies were terminated was wrong. Well, Croydon, of course, no longer maintained that position. You've heard very little about the 2011 Act and about the nuances of flexible tenancies. Their position now is that their submission as to how one terminates the fixed term of a secure tenancy is as true now as it was in 1980. You've never needed, say Croydon, to have a forfeiture clause, and you've never needed to use the forfeiture-style rights that were in the 1980 Act and the 1985 Act. And respectfully, I say that's not a position that's been adopted by anyone involved in social housing for the last 40 years. The practitioner texts don't support this view, going back to the 1980s. On the very limited occasions, I accept, when the lower courts have considered fixed-term secure tenancies, they haven't accepted Croydon's interpretation either. The Secretary of State hasn't accepted Croydon's interpretation, and we'll see when I take you through ground one, the importance that we place upon the Secretary of State's reading is not simply as the Secretary of State interprets legislation, but picking up on a point Lord Briggs made earlier, there's a reason why the 1980 SI remains relevant under the 85 Act, which is to do with the Housing Consequential Provisions Act. So Parliament endorses the Secretary of State's reading of it. And Parliament has subsequently, in the Housing and Planning Act 2016, made amendments to security of tenure provisions, which only make sense if Croydon are wrong. If Croydon are right, you don't need the 2016 Act changes. Now, those haven't come into force, and the present government policy is they won't come into force. All of those four features I'm going to elaborate on in ground one, but there's a fifth point why I say Croydon are an outlier, and I won't come back to this in ground one. So this is the overarching point I wanted to make here. They're not just an outlier in the sense of the presentation and the submissions they make to you today. They're an outlier among local authority practice. So when this case was still in the county court, as part of the work Miss Robbins and those who instruct us did to persuade the county court judge to transfer this to the High Court, we carried out an analysis of what's the practice of local authorities when they grant fixed-term tenancies. And you find that in page 242 of the core bundle. And if I can trouble you just to go to page 242. You should have a witness statement of Mr. Sheldon from those who instruct us. And for present purposes, the critical bit is his paragraph 6 on his page 244. So he did a trawl of local authorities who use fixed-term tenancies. He found 23, of whom 18 published their terms and conditions online. He reviewed those 18, and of those 18, 13 have classical forfeiture clauses. One has a sort of hybrid forfeiture clause that would cover some scenarios but not others. And only 4 of them adopt Croydon's approach of no forfeiture clause at all. this is, if not evidence in the traditional sense, this is the unchallenged material that's been available since the county court, showing how local authorities actually approach this and placing this case in its true context. And we suggest that the reality is that the majority of local authorities are well aware of the history of the 1980 Act and the 85 Act, the commentary, the supporting materials, and have appropriately drafted tenancy agreements. The second of the overarching points I wanted to make concerns the relevance or otherwise of common law positions and contractual rights, because my learned friend referred at various stages to the position at the common law or position under various contractual rights. Respectfully, we say the 1985 Act and the 1980 Act before it is a self-contained code. We get very, very little assistance from asking ourselves what the position was at common law. And when the courts have been called upon to consider the 80 Act and the 85 Act, that's been the position. The answer is in the statute, not in common law rules. So if we start with Harrison and Hammersmith, which starts in the authorities bundle at page 679, this is a case I will be spending some time on in ground one, but for present purposes, there's just a very short piece I want to take you to. So in the authorities at 679, this was one of, if not the first case about the 1980 Act to make its way to the Court of Appeal. And as Mr. Rutledge had outlined, what had happened is you had people who were periodic tenants prior to the Act coming into force. Notice to quit had been served prior to the Act coming into force. It had expired prior to the Act coming into force. But then the Act came into force. Did they become secure tenants? And the answer is no, because the property wasn't let to them at that stage. The letting had ended on the expiry of the notice to quit. But at page 691...
That was a fairly conventional application of the common law, presumably.
Well, the interesting bit about it is how the argument was put. The argument in Harrison is actually to do with the extent to which you can read across a Rent Act provision that would have had a different result. Could you read that across to security of tenure, to the 1980 Act? And the answer is no. Not so much for reasons of common law, but if you look at page 691, my lord, at G, 691 of the PDF, not of the report, at G, the conclusion there is that the Rent Act and the Housing Act 1980 are not in pari materia. So one isn't helped by reading Rent Act materials across. The policy is simply very different. So not so much a common law principle per se as the way the argument was put just didn't read across. But for my purposes, for this overarching point, it's on page 691 between A and B that I just wanted to draw your attention to. And it's the second sentence in the paragraph starting by contrast. So the starting point, the first time the Court of Appeal get their hands on the 1980 Act, the starting point is they say it's abolished altogether the common law principles on which contractual tenancies, both periodic and for a term certain, could be brought to or come to an end. And that general disinclination to look to the common law follows through all of the cases on security of tenure under the 80 Act and the 85 Act. Most notably, perhaps, the UKSC case, which again we'll come back to in a bit of detail, but if I can just take you to the key bits now. It starts at 697 in the authorities. UKSC is a slightly odd case. It's all on assumed facts in the context of effectively a strikeout application. And the actual conclusion is to grant leave to amend, to run a different argument. It's all about whether or not common law rescission is available where someone has made a false statement. The statutory ground not arising because the person who made the false statement is no longer the tenant, or, alternatively, because the false statement hadn't induced the tenancy as a result of the assignment. But if we look at two parts of this, look at 703, paragraph 17. We have a slightly more developed discussion in there again about why one can't come back to the Rent Acts, despite council having tried once again to rely upon Rent Act authority. Now the answer is that the Rent Act, of course, did preserve the landlord's rights to terminate in any lawful method. I'm looking at the paragraph starting in the paragraph at F, starting the Rent Act 77 does not identify, all the way to the end of that part. The Rent Act did leave the position at common law open. You could have any common law permissible method of termination. But the 85 Act is contrasted with that in the last sentence of that paragraph. The only way to bring secure tenancy to the end is through Section 82.
Could I just add a marginal note by way of a question? Reference has been made to the Protection from Eviction Act 1977.
Yes.
That only protects the tenant, does it not, where the landlord seeks to re-enter. It doesn't stop the tenancy terminating if there's a specified event
Quite.
in which forfeiture is exercisable. I just want to clarify that because it wasn't very clear to me this morning.
Quite. So they do two different things. So the PEA 77, which starts in the equivalent statute of 65 and then transmogrified into the Rent Act 65 for a bit and is now in the 77 Act, that's about keeping you in possession. Yeah. It's not about your security, your occupation status, if I can put it that way.
So the tenant could find that as it were, the carpet were pulled from under his feet.
Yes. The
tenancy's gone.
Quite. And often that's the predicated effect of 77. Imagine you have a contractual tenancy. I serve notice to quit. Your contractual right has ended, but nonetheless you must still go to court. In a pure contractual tenancy, assuming the notice was valid, you don't have a defence, but nonetheless you must go to court and a possession order must be obtained. Bailiffs must be sent in the usual way. But your tenancy ended by the Landlords Act, not by the Courts Act. The court regulated your eviction.
So it didn't deal with forfeiture. But is your submission that 82, Section 82, does in fact dispose of the problem of forfeiture for public sector tenants?
Yes. So, so I'll come to ground one shortly as I'm getting it. Our submission is, and you see it most clearly in 1980, but I'll follow it through into all the acts. Our submission is that there are two kinds of tenancy that fall within what's now Section 82. The periodic tenancy, where you use the grounds for possession in Schedule 2. The fixed-term tenancy subject to termination. Subject to termination means forfeiture and forfeiture alone. There is no other permissible method of termination it refers to.
Well, what is the legislative policy which makes it appropriate to say that if you want to grant a fixed-term tenancy, you can't do so subject to a condition that if you need to redevelop, you might have to rehouse the person? That's just off the table on your approach.
No, respectfully, no. That's running various things together. And under a huge assumption in Croydon's case is that what they've called the strategic management grounds are not available because no default no default is involved to engage forfeiture. That's just wrong. Default is not the critical element of forfeiture, and we'll look at this in Woodfall. Default is common; it's commonly the ground for forfeiture.
Well, when I read Woodfall last night, it said explicitly that you can't forfeit in circumstances like redevelopment.
Well, let me take you to the Woodfall bit in due course.
Yeah.
But no, you don't. It's not limited to default. It's an event. Default is sufficient but not necessary. What you need in order to forfeit is a clause that triggers an event, and we'll look at this in Woodfall because that's how you deal with the bankruptcy ones. Bankruptcy, as Woodfall says, is hard to describe as a default. It may be unfortunate, but it's not a default.
But it is something that's happened to the tenant.
Exactly, an event.
Rather than merely a desire on the landlord to get the property back so he can redevelop it.
An event has arisen, yes. There is nothing to stop you on my submission. Again, time permitting, I'll take you to a local authority whose tenancy has done this. There is nothing to stop you having a clause in your tenancy, your fixed-term tenancy, that says you are subject to forfeiture on any of the Schedule 2 grounds of possession. What you need, the purpose of going down the exclusive forfeiture route, or rather, to answer my Lord Leggett's question. The policy is that's how the Act fits together, because that's what the Act deals with in Section 29 of the 80 Act, Section 86 of the 85 Act, and we'll see there are other indications from other statutory provisions that push us down that route. But that's our when we get to ground one, that's our submission. You have a periodic tenancy, and you move to the grounds for possession, you obtain and execute a possession order. If you have a fixed-term tenancy, your only remedy is to terminate, whereupon the statutory periodic arises, and the only way of terminating the fixed term is by forfeiture and the forfeiture style provisions.
Well, what's the rationale for that? If you need to redevelopment, why do you have to go through the sort of mumbo-jumbo of having a forfeiture clause that then stretches it to redevelopment, downgrading the tenancy to a periodic one, and then terminating it?
Because the scheme of the Act is to give fixed-term tenants greater rights than periodic tenants. They're not supposed to be the same. And you'll see this when we look at the Secretary of State's prescribed form. There's an important difference between his prescribed form for periodic tenancies and secure tenancies. If you are a fixed-term tenant, you are intended to be in a better position than a periodic tenant. And one of the ways you are in a better position is you have this effectively two-stage process of the court terminating under Section 82(3)(4), and then
two stages can be done at exactly the same time.
They can be done at the same time, yes.
And so how are you better?
Well, even if they're done at the same time, you're better because of 82(4), which incorporates all of the law relating to forfeiture. So you are protected by the wealth of authority on waiver, on equitable relief, etc. That's simply not available to you as a periodic tenant. It is harder to evict a fixed-term tenant. I accept that's a consequence of what I'm arguing for. But that's because you're intended to have more as a fixed-term tenant.
But I thought you were going to say, going back to our conversation about the 1977 Act, that the change which Section 82 makes is to stop the landlord serving a notice saying, your tenancy is gone. One of my grounds of forfeiture has occurred, event, you no longer have a tenancy. It's not a question of taking proceedings, so the 77 Act doesn't protect the tenant. His tenancy is gone. Now, Section 82 will have the effect of ensuring that the landlord has to go for the court order and can only do so in the ways in which the section contemplates, which in the case of where you have the forfeiture clause, you, the landlord, can say, I still want the benefit of the forfeiture clause, but you have to go to court and show that you had a ground under Section 149.
So when the first half of what my lady just put to me, I'd agree with. The second half, I disagree with slightly. And when I come to the 1980 Act and I take you through the chronology of it, I'll respectfully set out why we say that. Sorry, my lord, I saw you drawing breath. No?
I beg your pardon. Certainly, for my part, I understood you'd be looking at...
No, sorry, my lord, no.
Stephen, for my part, I would certainly welcome being walked through on your submission the operation of the 1985, of the relevant provisions of the 1985 Act.
Of course.
And whether you take that after the 1980 Act or not.
Of course. Well, if I just finish off this last overarching point, and then I'll turn to ground one, because it's clear that's where there's most interest. The last point in my overarching point in UKAC, I just wanted to draw your attention to paragraphs 28 and 29 on page 706. Because again, my learned friend addressed you on the principles of the common law not being lightly ousted. Well, 28 and 29 tell us it's been ousted.
Oh, that's the rescission point.
Yes.
Yeah.
Now,
Yes.
it's going to be said at some stage, I'm sure, UKAC was a periodic tenancy, and that's true, it was. And we'll look at this later on, the 4 paragraphs starting at 32 to 35, that is the most detailed discussion of fixed-term secure tenancies that exists in any of the previous case law. So I'll do 32 to 35 in a moment. But this is why UKAC is very important, because it's the analysis of the Act as a whole, and it's the only place you have in any of the previous cases of any analysis as to how fixed terms actually fit in. So can I turn then to ground one, having outlined our submission, which is you need a forfeiture clause and you need to exercise the forfeiture style route under sections 82, 3 and 4. That's been our submission all the way through. In the High Court, we managed to persuade the High Court judge you needed a forfeiture clause, but then she said it didn't matter. Once you had it, it didn't matter which of the routes you got through. In the Court of Appeal, we got the other result, where they said, no, you don't need a forfeiture clause, but you must use the forfeiture style results. I maintain the submission that the properly understood, it's always been the position that you need a forfeiture clause and you must use the forfeiture style remedy.
But a forfeiture clause defined in your very broad terms as not being a default baseline.
Agreed, yes, and I'll make that good as well. I don't shy away from the fact that I'm saying that you can have a very broad forfeiture clause, and we'll look in a moment, time permitting, at one local authority whose agreement we've relied upon since the High Court, who we say we got it right. There's one authority I can show you from the analysis we did earlier who did get it right.
You need to make it broad enough to encompass all the grounds, but not so broad that it fails to trip up the Croydon in this case.
Possibly. Can I start with the 1980 Act? Because I know we're looking at the 85 as it currently reads, but 85, of course, is a consolidating statute, and so understanding what happened in 1980 is critical. And we start with section 32, which is at page 296 of the authorities. We say 32(1)A and B are identifying the two kinds of tenancy that are going to be governed by these provisions on possession. The first part of the main text of 32(1), i.e. they cannot be brought to an end by a landlord except by obtaining an order of the court for possession of the dwelling house, that relates to the 32(1)A tenancy. Or, an order under subsection 2 below, relates to the 32(1)B tenancy. And we say, firstly, that's the most natural reading of section 32, because subsections 2 and 3 then inform how you deal with the 32(1)B tenancy.
Well, the first problem with it is it doesn't cover the whole ground, so it leaves a category of cases for a term certain which don't have a forfeiture clause, and yet you have to say that they can't be brought to an end, although the legislation doesn't, on the face of it, would leave the landlord free to end them on contractual grounds.
Doesn't section 29 deal with that?
29 deals with that, yes, precisely. 29, in my submission, supports the reading I'm urging upon you, because 29 envisages two and only two scenarios in which a fixed-term tenancy ends. It ends through passage of time or an order under section 32(2). An order under section 32(2) is a termination order, which incorporates 32(3), all of the law on forfeiture. For Croydon to be right, there's a lacuna in section 29, because Croydon's argument has to be that there's a fixed-term tenancy which is not capable of termination by the section 32(2) route, but capable of termination by some other way, and yet it's been left out of section 29. So, to put it another way, why did Parliament create a detailed regime governing the forfeiture style ending of a fixed-term secure tenancy in 32, 2 and 3, and 29, if actually it was always possible to end a fixed term by some other route? Croydon's argument is that there's a subset of fixed-term tenancy, which is the one that gets regulated by this route. But in the broadest sense, a fixed-term tenancy is subject to any other termination method. Just doesn't fall within section 29. And so they have to say you could deal with it under 32(1), obtaining an order for possession. And we'd say that's not the most natural reading of it. There are two kinds of tenancy: periodic, or term certain, subject to termination. What does subject to termination mean? You're told in 32(2) and 3 and 29. It's forfeiture. There's further support for that in our submission in section 29 itself. So look at 29(2) and see how this statutory tenancy actually works. The periodic tenancy that arises, if you look at 29(2)(b), is on the same terms as the first tenancy, save that it doesn't include any provision for re-entry or forfeiture.
But if you terminate, sorry, if it is a fixed-term tenancy that comes to an end by a possession order, then it doesn't fall within section 29.
No, I agree, and I say that can't happen. I want to be clear about that.
Why not?
Because that then means that what Parliament has done is provided this detailed regulatory regime in 32(1)(b), 2, 3, 29(2) for a mere subset of the fixed-term tenancy, and we just say that's the wrong reading of that. It's the two kinds of tenancy. Periodic, move to the grounds for possession. Fixed term, have a forfeiture clause, use the forfeiture remedies, bring the fixed term to an end, statutory periodic arises on precisely the same terms, save that there is no provision for forfeiture or re-entry to be included, which begs the question that they presumed it was included in the first place. You don't need to exclude in 29(2) provisions for re-entry or forfeiture unless they were initially there and now have to be excluded.
But what if they weren't initially there?
If they weren't initially there, if you granted a fixed-term tenancy with no provision for forfeiture, you have to wait until the end of the fixed term, whereupon the periodic arises.
And where does it say that?
Because that is what envisages, that's section 29(1), the passage of time. That's how it worked. If you wanted to confer security of tenure for a period of time with no reservation to the landlord, you could do that. It's perfectly lawful to do that. You can still do that today if you want to.
It does depend on an extraordinarily broad definition of forfeiture.
What?
Because if this is to encompass, which is the principal sticking point, the redevelopment break clause, that's got to be a form of forfeiture under your approach. But generally speaking, forfeiture is described as a security for the performance of the covenants. That's what equity describes forfeiture as. That would not appear to be applicable to a redevelopment break clause. And how on earth would you grant relief from a forfeiture occasioned by the service of a redevelopment break notice?
Well,
and whoever, when exercising redevelopment break clauses, has served a Section 146 notice.
Well, relief troubles me less, respectfully, because, of course, relief being equitable discretion, it may not be a case for it. And given that the local authority will likely rehouse anyway, query whether
forfeiture is inherently, relief from forfeiture is an equitable concept which bases itself on the proposition that the forfeiture is only a security for the performance of the covenants, i.e. it's inherently fault-based.
I agree. I'm not ducking the point. I am happy to deal with the forfeiture bit, but I really want to make some progress in taking you through the history of it.
Yeah.
Because we ought just to recall the Law Commission had reported on forfeiture in very critical terms.
Oh, yes.
And that was before the 1985 Act.
Oh, of course. What I would also say on that, of course, though, is that if you are a tenant, you may well prefer to face forfeiture proceedings and, say, break clause proceedings precisely because of the equitable intervention. So there's nothing inconsistent with the idea that you give tenants greater security by incorporating forfeiture provisions, because the entire law of relief for the last 150 years has been, in very simple terms, a very pro-tenant development. Equity generally leans against forfeiture, etc., thinking of those line of cases. But can I move on, though, to the Secretary of State's interpretation of this? Because this becomes more important in 1985, although not for a reason that anyone's canvassed yet. At page 526 of the authorities, these are the initial regulations made, as I think Lord Briggs noted, around a month before the Act came into force. Royal assent is in early August, commencement is in early October, it's made in between there. And you see it's Regulation 2.2, prescribing a form of notice for termination of the secure tenancy, which is for a term certain, and for possession of the dwelling house let under that tenancy, picking up on my Lord Stephen's point that you've always been able to do both at once, the terminate and the move to possession, shall be in the form specified or a form substantially to the same effect. The form itself is on page 529, and it's note 1, case to which this notice applies. There are 2 points I ask you to I take from this commentary from the Secretary of State. The first is, if you look in the first sentence of it, he describes a situation where you're a tenant for a term certain which contains a provision enabling the landlord to bring it to an end before the fixed term. Such a provision is called a provision for re-entry or forfeiture.
Yes, but it's a default provision, because it's to bring the tenancy to an end before the end of the fixed term if you get into arrears or break some other condition of the tenancy.
That's not the point I take from it, my lord. I think I'm taking it is.
But I can't help noticing it.
No, quite. And I'm really not shying away from it. I will deal with the forfeiture point.
Okay.
But it's the interpretation point. Enabling the landlord to bring it to an end. He's mimicking the language of section 32, termination by the landlord. The critical bit is the Secretary of State has described that as being a provision for re-entry or forfeiture. The second thing I ask you to note is the last sentence, where the Secretary of State says the Act confers additional rights on tenants, which are described in the following notes. One wonders what he means by that. Additional to what? In my submission, what he means is additional to those that a periodic tenant would have. Because contrast the periodic tenant's possession notice on page 527. The equivalent note 1 doesn't mention any additional rights. Now
But the additional rights, are we at the bottom of page 529?
Yes, at the end of note 1.
Well, they're the additional rights which are described in the following notes. And those aren't notes showing rights additional to those enjoyed by a periodic tenant. They're showing rights which are additional to those enjoyed by a common law tenant with the usual equitable protection against forfeiture.
Yes, the point I was simply trying to make was he hasn't used the same language for the periodic tenant. So he clearly thinks that a fixed-term tenant does have something that a periodic tenant doesn't have. I appreciate the point there. It's a slightly strange way of describing it. But in his two prescribed forms, he's told fixed-term tenants they have something additional. And respectfully, I'm saying, yes, what's additional is he's drawing the distinction between the periodic and the fixed term.
But he's not, because those are almost exactly the same as the ones he set out in the notes under the periodic tenant.
It's a slightly tortured point, and I don't want to get bogged down in it if it's not going to be helpful, because the most important bit of this submission is is the first bit I asked you to take from it, that he equiparates landlord bring it to an end before the end of the fixed term with a provision for re-entry or forfeiture. That's the really important bit I want to take from it. Now, the usual caveats with relying on secondary legislation would apply at this stage, I accept. And just for completeness, if I can trouble you, my lords, my ladies, to turn to page 921 in the bundle. Rather than ask you to trawl through well-known case law, at 921 in Benyon, I just draw attention to indented 3 and 4 taken from the Hanlon case, which are the points we rely upon. When an interpretation is consistent, when regulations are consistent with a certain interpretation, that tends to confirm the interpretation. And when it's a framework built on contemporaneously, the regulations can be a guide to the statute. At that stage, that's all I want to take from the 1980 SI. I then move to 1981. I won't do every year as slowly as that, but 1980, that was the Act and the SI. 1981, sorry, before I left 1980, I should have said, just drawing your attention to the commentary from the practitioners. I'll give you the reference for it only. It's 878 in the authorities. The initial commentary suggested in current law statutes that these were two distinct routes. Possession order was only applicable to periodic tenancies, termination was the only route for fixed-term tenancies. 1981 takes us to the Harrison case that we looked at briefly in my opening. And I need to take you back to page 691 in the authorities. And I say, when you read that passage A to C, starting by contrast and ending section 32.2, I can just trouble the court to read that.
So sorry, I misheard your page number.
Sorry, it's 691 of the PDF.
691, thank you.
691. And it's A to C, starting by contrast down to 32.2. So, by 1981, I say what you get from that paragraph is the court drawing this distinction between the periodic tenancy, however it arises, which is the one that requires the possession order, and then by contrast the fixed-term tenancy, which they only envisage being dealt with by way of re-entry or forfeiture. So the initial reading in my submission was the same as the one we urge upon you. Periodic, however it arises, grounds for possession. Fixed term, re-entry or forfeiture only. There's no gap, there's no third category. Those are the two forms of tenancy and those are the two routes for possession. And again, moving forward in time to 1983, by this time we say that was certainly the understanding of the practitioners. So if I can take you to page 882. This is now from Mr. Arden's housing law, and it's his paragraph 22178. And it's the first 5 lines of paragraph 22178 in particular. He identifies 2 kinds of tenancy: periodic, which you obtain a possession order, or fixed term, subject to re-entry or forfeiture. So by 1983, the commentators are reading this in the way that I asked you to read it. They're saying that termination by the landlord in section 32.1 means termination by forfeiture. There's no third category of fixed-term tenancies that are being terminated under some other route. We then get to 1985, but we start not with the Housing Act of 1985, we start with the Housing Consequential Provisions Act 1985, which is at page 477 of the authorities. So my Lord Briggs raised the point before lunch about people using the 1980 SI for 2 years after the 85 Act come into force. Yeah. The reason for that is subsection 2.2 on page 477. But the transition from the Housing Act 1980 to 1985 wasn't a statutory instrument dealing with transitional provisions or a saving clause or similar. A freestanding act was passed, and the effect of which at 2.2 was to treat statutory instruments made under the 1980 Act as having been made under the equivalent provision of the 1985 Act. And in our written case, just for your notes, at page 76 of the bundle, we've done a table showing you where each provision of the relevant provision of the 80 Act went to in 85. But that's why people carried on using the 1980 SI for 2 years afterwards. So by now, not only do we have the Secretary of State's interpretation, which we say is consistent with ours, but Parliament has approved that statutory instrument and has given it continuing validity, notwithstanding the repeal of the governing Act. I don't want to overplay it, but we move from it simply being the Secretary of State's opinion about what the Act meant to being an opinion that Parliament has endorsed by the continuation provisions. Unsurprisingly, given that the 1985 Housing Act is a consolidating statute, and given that the Consequential Provisions Act provided for the 1980 SIs to continue to be relevant, the commentary, when we get to 1985, doesn't change at all. And for your completeness, again, page 887 in the authorities bundle takes you to Mr. Arden's comments in 1985 on the provisions. But when the court has time to look at them later, you'll see there's no change. There's no change from his 1980 view to his 1983 view to his 1985 view. Which then takes us to the Housing Act 1985 as enacted, which one finds at page 318. Now again, we say this is to be read in the same way as the equivalent provision in the 1980 Act. 82.1a identifies the first kind of tenancy, the periodic tenancy. 82.1b identifies the second kind of tenancy, term certain but subject to termination. The one that cannot be brought to the end except by obtaining an order of the court for possession is the 82.1a tenancy. The one that is dealt with by obtaining an order under subsection 3 is the 82.1b tenancy.
Well, why does it say the first cannot be brought to an end and the second cannot be brought to an end?
It's always possible, I completely accept, to write something in clearer language with the benefit of hindsight.
Why use the word all?
Because it's simply drawing that distinction. It uses one word to achieve the effect of identifying each remedy for each kind of tenancy, rather than having a slightly longer form of wording, something like, say that a tenancy under 82.1a can only be brought to an end in route A, a tenancy under 82.1b can only be brought to the end by route B. If you just start with 82, it becomes a lot less clear than if you start in 1980 and see the evolution through. And there's no material change between the 1980 Act and the 85 Act. The only difference is that what's now 82.2 was previously in the text of 30.2.1, So they've just broken things up slightly. But the reading is the same. Weekly or periodic possession order, fixed term, get an order under the forfeiture style provisions. And section 86 follows the same approach as in section 29, yes. Page 324 of the authorities. It's the same point. It only deals with two kinds of tenancy. It assumes, 86.2, that the fixed-term tenancy that came to an end by whatever route has come back to life as a statutory periodic tenancy, save that the provisions for re-entry or forfeiture have been excluded, which presupposes they were there in the first place. You then move to 1987, page 535 in the bundle. The prescribed forms are reenacted. The reason for the change is to do with a new ground for possession that was introduced in 1986. But at 535, this is the form that's prescribed for fixed-term tenancies, and you'll see the Secretary of State uses the same wording. I won't press the point about additional rights, as I'm not sure it's necessarily such a good point. But the first point is still the good point.
Yes.
So far, respectfully, the reading's been entirely consistent across the Act, across the commentary, across the Secretary of State's interpretation of it, and to the limited extent they've looked at it, the cases. Well, you then get to 2006 and the UKSC case, page 707 in the authorities.
Are you going to show us the amendment made to Section 82 in 2004 at some point?
I'm going to take you to I'm going to do 2006, then I'm going to do the Act as it currently reads, then I'll do the change that was made by the 2016 Act that isn't yet in force.
Could you cover 2004 along the way? Because
I can try and do 2004 along the way. I'll do it when we do it as it currently reads.
Just because it seemed to me that wording, at the moment, I think, impossible to reconcile with your interpretation.
That's helpful, thank you. I'll deal with that. I'll do UKSC at 707. When I've got the Act back in front of me, I'll pick that point up. UKSC at 707. So remember, in UKSC, we've been dealing with the attempt to rescind full misrepresentation as a common law remedy, which the Court of Appeal has held is not available because Section 82 is a complete code. It's paragraphs 32 to 35 that are important. Because, as is clear from UKSC, all the argument had been about periodic tenancies because that's what has been granted in that case. But after the hearing, Mr. Arden sent a note. Mr. Arden is arguing for the availability of rescission. He sends a note to the court drawing attention to how would this work in a fixed-term tenancy. I won't read all of 33 to 35 out to you. In the interest of time, I'm just going to make two points about it, about what I say is helpful for us on. Firstly, paragraphs 33 and 34 assume the correctness of the submission that I'm making to you, because they assume that brought to the end by landlord means brought to an end by forfeiture. Now, you might say that shows nothing more than Mr. Arden's been consistent in his view since 1980. But it does show that no one suggests that's wrong, that assumption. And second point I asked to draw to your attention is paragraph 35. Coming back to the point that even in the context of a fixed-term tenancy, Section 82 and 84 are the complete code. You've got to come through the statutory route. Nothing else is available to you.
I have, I think, difficulties with paragraph 35 on which I'd welcome your help. The first is the idea that a forfeiture clause can deal with a pre-lease misrepresentation if it's meant to be a security for the performance of the covenants under the lease. And the second is discerning a policy of excluding the termination of a fixed-term tenancy for misrepresentation when ground 5, I think it is, actually provides one.
But only in very limited circumstances, of course. So ground 5 wasn't available in the circumstances of UKAC because it wasn't. No,
because it wasn't by the misrep wasn't by the right person.
And the person who was holding it hadn't induced the grant of the tenancy.
Yeah.
And one of the points that's made in the course of the argument in UKAC is, but ground 5, misrepresentation as a remedy would not ordinarily be available, it's suggested, to landlords under secure tenancies because you could end up with a situation where the wholly innocent party ends up losing their security of tenure. If you just have misrepresentation at common law as a remedy available for a secure tenancy, then someone who played no part in the misrepresentation could lose their security and could lose all that comes with that. And that, again, we can look at it if you need to, but that's part of the reasoning as to taking the very strict approach to ground 5. It's got to catch everyone. And if you take a very generous approach, you risk undermining the purpose, which is to confer security. The question about a prior representation, that is, I would agree, a more difficult one. But of course, don't forget that during secure tenancies, there will effectively have to be a series of continuing representations by the tenant that they occupy as their only or principal home, being the most obvious one. Because the moment you cease to occupy as your only or principal home, you lose security. Oh, yeah. So the idea that secure tenancies may be looking over a period of time is less controversial than if we are talking about commercial leases, for example.
Yes, but
what's the policy which justifies preventing you from terminating a fixed-term secure tenancy for fraudulent misrepresentation at the outset? Unless you put a clause to that effect, I think, is that what it's saying?
Yeah, unless you have a forfeiture clause.
A forfeiture clause which says that. I mean, why should you need a forfeiture clause which says that when the Act ground doesn't allows it?
Because Parliament
and your contract allows it.
Because Parliament has decided that there is a scheme of tenancy that will be regulated exclusively by statute and not by the contractual position, and that's why. And Parliament can
Well, it is regulated by the contractual provision to the extent that you need the magic form of clause in your contract, according to your submission.
But what Parliament is doing is it's saying that you have to have a particular form of clause. You exercise that relying upon a ground to terminate, then a ground for possession. Parliament controls security of tenure in the social housing sector through adding to the grounds where it needs to, not by leaving open common law remedies. And you saw this when Mr. Rutledge took you to some of the grounds. Grounds were added after the 2011 London riots, for example, to make it a ground for possession where you're convicted of an offence in the location of a riot. The domestic abuse grounds are changed on a regular basis to catch up with changes in the way that abusers deal with things. You see,
just emphasise that the purpose of this legislation is social as well as security. Social in many different ways.
I don't disagree with that. The purpose of the 1985 Act, Part 4, is to provide a certain class of persons with a certain degree of security of tenure.
But what is the policy for channeling the access to those legislative grounds through having a special form of forfeiture clause, which stretches perhaps beyond the limits of what's normally encompassed in a forfeiture clause?
The way, perhaps to answer it this way, almost all analysis of secure tenancies starts with periodic tenancies. Whether academic writing or the case law or the commentators, whatever it's going to be, because they're by far the most common. Fixed-term secure tenancies were intended to be something different to periodic tenancies. And they were intended to be a greater form of security. My own friend alluded in his submissions to some of the commentary early on. One of the examples that's given is that you could, if you were a local authority, you could grant all the fixed-term tenancies, and where your tenant misbehaved in some way, you could terminate their fixed term, but leave the periodic in situ. It gives you an opportunity to give them a chance to mend their ways, improve their behaviour, improve their rent payments, cease being antisocial. The point is...
But if on the attempt to forfeit, the tenant said, I want to behave in the future, he'd probably get relief from forfeiture, so the tenancy wouldn't be terminated anyway.
Quite possibly, but that's the court getting involved in it.
Well,
but that's the other limb of this.
But you can't do it without the court getting involved.
And that's the other limb of this. This isn't about empowering the landlord. It's about empowering the court to make that decision. That was the change from pre-1980. The local authority decided to end your tenancy, it served notice to quit. You had the possibility, at that stage remote, I suggest, of public law grounds and a claim for judicial review. One of those things, frankly, more theoretical than real, I would suggest. That's the change.
There are differences between fixed term and periodic, but there could also be a difference insofar as what is reasonable under all the grounds apart from 9, 10 and 11 would be influenced by the nature, the fact that one is fixed term and the other is periodic. Could be, depending on the circumstances.
I wouldn't dissent from that. It's the idea of reasonableness as an element of a possession claim is as old as the hills, and the courts have consistently rejected any attempt to cut down what the district judge or the circuit judge considers reasonable in these circumstances. So I wouldn't dissent from that.
But are you saying in your responses that it comes back to the point I thought I was making earlier, that the purpose of Section 82 and its predecessor, Section 32, was to ensure that everything had to go through the court? If it was forfeiture at common law, it would simply be service of the notice to quit or whatever, the event, whatever it was, so that you didn't have security. So this was intended to give you security by ensuring that the landlord couldn't claim that the tenancy was at an end until he'd persuaded a court to that effect.
Yes.
And that's a very big point, surely, for the tenant.
Yes.
Otherwise, he finds himself capable of being tossed out on his ear.
Yes, if I wrongly disagreed with that earlier, I was very much wrong to disagree with it. Yes, that's what's happening. The power of the landlord is being circumscribed, and what's happening is you're giving the power to the court. I'm conscious of time. Can I move on to the 85 Act as it currently reads? Well, I'll deal with some of the other changes that were made between 1986 and 2011. It's page 336, I think, for the Act as it currently reads. Now, there have been two changes that are material for Section 82 between the enactment and now. The first is, you see in 1A, little a, it's now that the tenancy ends only on execution. That doesn't affect us here. That's to do with a problem called tolerated trespass that was created. Previously, the tenancy ended on the date in the possession order. So what happened if possession order ended on a Monday but suspended execution on terms they pay the arrears off over 6 months? It had been held that they became a form of trespasser. So it deals with that. The other change is the introduction of the demotion order under Section 82A. The demotion order, in my respectful submission, doesn't change anything about the reading of the Act. It's not a means of obtaining possession, which is the issue in this case. See page 34 of the key documents. It's a special remedy for antisocial behaviour. You effectively lose your security of tenure for a period of time. And during that period of time, you're subject to a mandatory ground for possession if you continue to misbehave. But after the demotion period, which is generally a year, you get a traditional secure tenancy back. And the reference for this is section 143 big B, subsection 1, Housing Act 1996, in your bundle at 492.
Demotion order applies to both weekly and fixed-term tenancies.
It does.
Yeah.
It does. So
without any distinction between them.
There are differences between them.
Now, why doesn't the order under why does the order for possession not apply to both, if the order for demotion applies to both?
Well, that's why I started in 1980 to take it through, because the 2003 Act that introduces the demotion orders is not intended to change substantive security of tenure. It's intended to create a new standalone remedy for a particular subset of housing management problem.
But this shows, doesn't it, that, I mean, now you can't just get to your result on this version of it by putting in the word respectively. You've got to do some serious rewriting of the section to get to your result. It shows that that's not what Parliament meant by it.
No, it shows that Parliament created an additional remedy for certain limited circumstances. The fixed-term tenancy does terminate when the demotion order is made. A periodic tenancy arises.
But where do we get you can only obtain an order for possession in relation to a weekly or periodic tenancy? You just can't get that out of this section.
Well, Lord, you do, because 1AC doesn't give you a right to possession at all. So if you are a local authority landlord and you want to evict your tenant on this statute as it currently stands, you need 1AA or 1AB.
Yeah.
1AC will not evict anyone.
Absolutely.
So we come back to the same question. Who is allowed access to the 1AA tenancy, and who is allowed access to the 1AA remedy, and who's allowed access to the 1AB remedy? And that's why I started.
Well, it doesn't limit anybody from having access, provided they've come in 82 1A or B. They can get access to any of the remedies in the next subsection that may be available, provided the grounds for them are satisfied.
But that, my lord, is why I had to start in 1980, because that wasn't.
Well, I know. So you say nobody can understand this Act unless they've gone through the previous history of it, as I understand it.
I say you can't understand the 1985 Act as it reads now unless you know what happened previously. Yes. That's why the history matters.
What happened previously was equally as clear that you didn't have to be restricted under to either a weekly tenancy or a fixed-term tenancy if you wanted to get a possession order. There was nothing in the section that stated that.
And my lord, respectfully, that's why we start off by drawing your attention to what Section 29 said and the two different forms it envisaged. The fact that Section 29 assumes that the tenancy that's been terminated had a forfeiture clause. That's why we took you to the Secretary of State's interpretation of it.
It isn't relevant, Section 29, if you get an order for possession. You've got an order for possession. Section 29 doesn't apply.
And therein lies the issue in the appeal. I say that you have the two different routes doing two different things.
I mean, if that was a possible reading of Section 32, that you could read it subject to respectively, it's no longer possible by the time you've got to the current version. Well, Parliament has removed any ambiguity that there might have been.
Well, there's two answers to that. One is, of course, that's not Croydon's case. I appreciate that's unlikely to trouble this court. But the second answer is, well, then look at what they did in 2016, which is where I end this part of the historical trawl. Can we go to page 505? So this is the Housing and Planning Act 2016. And if ever brought into force, this will represent a significant change in how local authorities deal with social housing.
This could be just clearing up the misunderstanding which you actually have adverted to. Well, that is that all the regulations, the academic articles have proceeded on the basis of a misunderstanding.
Well, let me. I will pick that up, but it's directly I say no. That's not the answer. It's for the second of two sections I'm going to ask you to look at. Page 505, 81A and 81B. 81A will be the new position on tenancies. You will be granting fixed-term tenancies as the default, with 81B providing for the Secretary of State to make regulations for residual categories, where periodic tenancies, which are now going to be called old-style secure tenancies, can be granted. The important bit, and respectfully the answer to my lord, is at page 502, where we see how Parliament amends Section 82 if the fixed-term tenancy becomes the default model. So 502, we have new A1 inserted, which will deal with secure tenancies going forward, and the provisions we've looked at will now only apply to old-style tenancies. And I draw your attention to two particular points. The first is A2, where they say it can be brought to an end whether or not it contains terms for it to be brought to an end. And by that, what they mean, if you look at the introductory description of the section in 119, they mean forfeiture without the need to forfeit. It all comes back to the same point. The assumption is always, whether by the commentators, the Secretary of State, or now by Parliament, that what you need is a forfeiture clause. And what they are doing now is bypassing that whole process. If 119, introducing new A1 and A2, ever comes into force, fixed-term tenancies will not really be fixed-term. It will be for so long as the landlord does not obtain a possession order under the Schedule 2 grounds. That's what Croydon say the law is currently. Respectfully, yes, of course, you could say it's an amendment to clear up an ambiguity. But as this is the only case to have considered this, it is unlikely that Parliament was aware of this ambiguity. Alternatively, it's an amendment that's consistent and only consistent with our reading of the provisions. I've been saying I would deal with the forfeiture clause point, and now, my Lord Briggs, having been very generous in letting me bat it off enough times, now I will actually deal with it. Page 926 in the authorities. And it starts 6 lines from the end. And this I will read to the court. So
this is Woodfall. It
is Woodfall now, yes.
Sorry, I missed the page number.
Sorry, 926, my
Thank you.
Woodfall doesn't seem to think it is a security.
Woodfall takes slightly more... what I suggest is Woodfall's clearly taken the opportunity in the very recent past, as we can see from all the cases cited in the footnotes, to revise its interpretation of this, because it's relying upon a 2020 decision for most of its commentary. But respectfully, I do say Woodfall is right, and this is the bit I want to take you to. However, it is considered that the existence of default by the tenant is not necessary before a right of termination is properly classified as a right to forfeit, unless default is given an exceptionally wide meaning. Thus, a lease may contain a right to forfeit on the insolvency of the tenant. Insolvency may be a misfortune, but it is not, in ordinary language, a default. So a lease may contain a right to forfeit on insolvency not of the tenant, but as a surety for the tenant.
Well, the bit I had in mind was the sentence before the bit you started to read out, beginning the reference to some default by the tenant.
Would exclude a break clause, yeah.
But they're discussing a particular case, conversely, where a tenancy was terminated on notice to quit in the event of default. And the construction of, in that particular case, the construction was not that it was not a default. That's the point of principle. But what you need is an event. The event may well be a default, but what you need is an event. And respectfully, again, we put this in the authorities bundle. If I take you to page 933, we've just taken a working example from a precedent book. At 933, look at, for example, 7.1 being a fairly standard modern form of forfeiture clause. 7.1.3, the tenant or the guarantor is subject of a bankruptcy petition.
But that is a form of default.
Yeah.
It's just the same as in a banking contract, where you can have an event of default, can be a breach of the contract, or it can be becoming insolvent.
Or it can be your surety becoming insolvent, or
Yeah.
some asset which you've charged as security falling below a certain minimum value.
Well, two answers respectfully. One is, even if it is a default, it's plainly not a tenant default. But secondly, no, that's not necessarily a default. It's an event. It's the subject of a petition. Not a successful petition. It's the service of a petition. And you see the same at 714, receivership.
But with respect, if a redevelopment break clause was a form of forfeiture, then Section 146 would apply to it.
Potentially, yes.
But it doesn't. Nobody ever serves a Section 146 notice when exercising a redevelopment break clause. And the court has no discretion to relieve you from the exercise of a redevelopment break clause.
Well,
because it's not a security for the performance of anything.
Well, one point where I do agree with my friend, he ended by suggesting that that context is everything.
Yes.
And with that, I very much agree.
Yes.
Because it's not forfeiture in the true sense under the Housing Act. It never has been. It's a form of it's a forfeiture style process designed to get you two things. One is an opportunity for the court to consider all the principles about forfeiture and relief. C29.3, C83.4. Secondly, it gives you the way of bringing the additional security, the fixed term, to an end. It may well be, and I have no difficulty with this submission, it may well be that it's slightly loose language to talk of it as forfeiture. It may be that what we should be talking about is forfeiture style provisions, or the forfeiture style provisions in the Act.
Well, I'm plainly thinking about a forfeiture that attracts Section 146. So if you use forfeiture so widely as to include a redevelopment break clause, you're going wider than Parliament plainly intended.
Well, they incorporate all of 146 and any law relating to forfeiture. This may be semantics, but whether that's to incorporate 146 or because it's forfeiture, or whether that's to say an equivalent protection as is found in 146 applies, maybe another matter. I'm terribly sorry, I didn't answer my...
I was just wondering whether you accept that in the true sense of forfeiture, there can be no forfeiture clause for redevelopment.
I don't think I would. And I appreciate... I appreciate that's a slightly bold position to take, but can we just look at Clay's at page 625?
But assume for one moment that in its true sense there can't be such a clause, a forfeiture clause. Are you saying that, in the true sense, are you saying that it should be styled in exactly the same terms as is contained in ground 10 in Schedule 2?
I am saying, and I'll come to this in a moment, I am saying that a properly advised local authority who wants to use what I say is the forfeiture style remedy for its fixed term tenancies should include within its terms of tenancy a provision which says I reserve a right to forfeit if any of the statutory grounds apply. And I'll take you to one in a minute where we say they've done that and it works. But the reason I'm slightly cautious about agreeing with my lord is if we look at Clay's at 625 of the bundle,
Yeah.
almost everyone, including the parties in this case, focuses on the bit in the first paragraph starting in the present case and starting, we accept for present purposes the submission that when exercised operates to bring the lease to an end or then it would naturally terminate and exercisable in the event of some default by the tenant. I just make two submissions. The words for present purposes seem to be quite important because they're not suggesting, although we all use this as a convenient shorthand, this isn't purporting to be exhaustive. And you see that, my second point about Clay's, at the very end of 625. The last sentence starting, a provision is not a forfeiture provision merely because it operates where there has been some default by the tenant. It's fundamental.
Well, but I mean, the forfeiture's been around for a long time. Can you give any example of a case where there's been forfeiture which hasn't involved some default by the tenant?
Well, the cases relied upon in Woodfall and in the Journal of Housing Law article that we cite relate to bankruptcy. And my lord will throw back at me and will say, but that is default. That is the extent of the answer on that.
But the point at the bottom of the page is simply that it's not enough that it's just something nasty that happens on a default of the tenant. It's got to bring the lease to an early end. Absolutely. That's coming back to his previous definition at the top of page 625.
But I entirely agree. It's fundamental that the forfeiture provision should bring the lease to an end earlier than the actual termination date. Yeah. So why does it bring it to an end? In most cases, it will be on an event of default, because that's what you draft. But it doesn't have to be. It could be on another event. And certainly in the context of this scheme, respectfully, it could be. Remember, you will serve your notice, under your fixed-term tenancies, you're going to serve your prescribed notice, which will have the effect of bringing the fixed term to an end. The prescribed notice has to refer to all of the grounds. So the draftsman clearly doesn't see, in this context of this act, any difficulty with you bringing a tenancy to an end under a fixed term by reference to any Schedule 2 ground. Now, that's a different question from, in the more general law of forfeiture, can we find circumstances where non-default is the forfeitable event, if I put it that way? And then we get into the discussion about, well, is bankruptcy a forfeitable event, a default or not? But in this scheme, there is no reason not to hold, respectfully, in agreement with the Secretary of State and in agreement, we say, with how this Act has been interpreted over the last 40 years, there's no reason not to hold that you can terminate using what's now Section 82(3)(4) through a forfeiture-style route for any of the ground 2 reasons. And that, if I may, is what, again, one of the local authorities that we surveyed at the beginning has done. If you look at page 256 in the core bundle, a question was asked, how would one draft one of these clauses? Well, Wandsworth did it. 256, forfeiture without prejudice to the above. Third bullet point, if any of the statutory grounds for possession exist, we may forfeit the tenancy. How will they do that? They'll do it by serving proceedings seeking possession or re-entering the property or any part of it, and thereupon your tenancy will end. No one has suggested in the High Court, Court of Appeal or here that this doesn't work. It does work. That is a forfeiture-style provision that engages sections 82, 1b, 3 and 4.
What is this document?
This is, so you remember I started by saying that we'd done a survey of the local authorities?
Yes, yes.
This is the London Borough of Wandsworth's tenancy agreement. So we've given you an example in the bundle of authorities who do have forfeiture clauses and how it works.
Well, it's an attempt. I mean, some might say it's an attempt to dress up a clause, if it's as wide as any of the statutory grounds for possession applying, as a forfeiture clause when it isn't.
Well,
It's
my
mutton dressed as lamb.
It's also an untruth because they say they'll be able to re-enter the property, but they won't.
well, they may if there's no one in possession.
Right, but if the tenant's reading this, whereas according to you, if you draft an honest clause, it says you'll have to go to court, that doesn't count as a forfeiture clause, and therefore it doesn't work.
Well, that is one of the oddities since 1964, of course, the requirement to get a possession order where the property is occupied. Peaceable re-entry now only applies where it is unoccupied, which in practice in residential property is very rare. It's commercial property hangover in reality. But since 1964, the standard language of re-enter has been, in many cases, a legal fiction.
Are you saying that, for the purposes of Section 146 of the Law of Property Act, that a covenant or condition triggering the rights under that section has to involve default?
No. I say the scheme of this legislation is that you have to terminate the fixed-term tenancy by virtue of the prescribed notice and then obtaining the termination order. You also have to incorporate Section 146.
It doesn't make much sense, Parliament giving the landlord the option to use Section 146 unless it has the full breadth of Section 146, i.e. a covenant or condition.
Well, we can see that Parliament's excluded some of 146 because they exclude subsection 4, for example. Now, the reason for that is because, of course, you shouldn't be subletting your social housing property anyway, so there shouldn't be any tenants looking for relief. But the principle, respectfully, we do say it is a permissible answer to say that some parts of 146 may end up being more important than others in any particular case. What Parliament's doing is ensuring that you get proper notice and an opportunity to rely upon all the rules about forfeiture, waiver and such like.
But I thought this really was going with the grain of the argument, that you're saying there are no grounds in Schedule 2 which can't be used under the forfeiture provision.
I do say that, yes.
So we've got slightly wider wording, haven't you? Covenant or condition.
Yes, I see your point. Sorry, yes, I now see. Yes, potentially.
Maybe a bad point. I just wanted you to help me.
But I suspect condition would still apply, because we canvassed this earlier. It will always be a condition of a secure tenancy you occupy as your only principal home, because it's integral to a secure tenancy. And you might be in breach if you don't. Exactly. You probably would be in breach if you don't. Yes. So condition. We need to think in perhaps a bit more detail about the kinds of conditions that are effectively condition precedents to there being a secure tenancy, but that would be the obvious one.
Condition the property is not required for redevelopment?
Possibly. I'm not troubled by the idea that the statutory grounds should be available. I simply say it's simply how you get there. Yes. I'm conscious of the time, Mr. Bates. We've been asking a lot of questions about what's effectively ground one, but we haven't so far heard at all from you on ground two. No doubt you'll want to rely on your written case, but you've heard what's been submitted the other way. I do. Ground two. Can I just check my notes on ground one? Check there's nothing else to do. Please, yes. Yes. I just want to make sure you do get time, because we really can't extend time. Oh, no. I understand. Bearing in mind the constraints of a full day hearing. Of course.
I'm happy to give way for 5 or 10 minutes. I
think you can have 3 minutes locked off anyway, because you went slightly over 1 o'clock. That's very generous. Thank you very much. That's very kind. Thank you. There's just one other point I wanted to make on ground one, then I'll deal with ground two very quickly, but I'll just do the page references for you. One of the points that Croydon make in their written case, and featured a bit in their oral submissions, is about the problems with housing management that might arise if you've got no right to possession. And here we simply say, well, there are other remedies. So let's take the two most common tenant problems, rent arrears or antisocial behaviour. Rent arrears,
you have all the remedies that anyone else who owed money is. Deductions from benefits, third-party debt orders, money judgments, etc. Injunctions, the statutory purpose since 1996 has been to try and deal with antisocial behaviour by injunction. So in the bundle, I'll give you the references. You've got page 495. You've got what's now the Antisocial Behaviour Act 2014. That's now where you find the primary powers for dealing with antisocial behaviour. Section 2(1)(c) on page 497, it includes housing-related antisocial behaviour. Page 498, there's a power of arrest. 499, you can even exclude someone from their home under these injunctions. So if you've granted a tenancy and now you regret your inability to get people out, there are other remedies that are available to you. Moving then to ground two. In some respects, it's a strange one for us to address because obviously it doesn't arise on the facts of our case because no forfeiture is claimed against us.
We nonetheless welcome to.
I rather thought you would. Having suggested permission should be refused for that reason and having got nowhere, I didn't imagine you'd simply allow me to stand here and say that as an affect us, we won't deal with it. My respectful submission is this, and I'll give you some page numbers for it. You can see what a standard form of forfeiture clause looks like by looking at paragraphs 7.1 and 7.2 on page 933 in the authorities bundle, or by looking at the Wandsworth one that I just took you to at page 256 in the core bundle. I do respectfully suggest that given that Croydon clearly weren't trying to include a forfeiture provision, it would be surprising if by a side wind they had managed nonetheless to confer upon themselves a power to forfeit. But ultimately we say that the judge is right for the reasons she gave. So if we'll go through them very quickly. Page 141 of the core bundle. It's the paragraph that starts, "We will not hesitate to take action. Such action will, where appropriate, include seeking possession. This could result in you being evicted for your home." Well, nothing ends under that provision. That's just a description of steps they might take. The second clause they rely upon is at page 144. "We may also take eviction action at any time if one or more of the grounds for possession applies." But eviction action is not termination of the tenancy. It could be service of the notice seeking possession, whereupon the tenant remedies the thing that's being complained of. Service of the notice would be eviction action. Nothing ends under that provision. Page 150. "We may end a secure tenancy by first serving a notice of seeking possession and applying to the court for a possession order." Or respectfully, that's the description of how the Act applies to periodic tenancies. That's not a forfeiture clause. And then page 153, clause 10, that's simply saying that they may seek possession. Nothing will end. And that's just alerting people to how the statutory scheme works for secure tenancies. Finally, in their written case, my own friends place a lot of weight on the Richard Clark and Widnall case. I'm going to take this very quickly and just do the page references again, if I may. Page 834 at D to F, so 834 of the authorities bundle, D to F in the report, is the prohibition in question. Roman numeral 1 is the forfeiture clause, and Roman numeral 2 is a short notice termination provision. At 835 and then B to E, the argument is from the landlord that if he proceeded under 1, the forfeiture provision, then all the usual rules on forfeiture would have applied. But he wasn't. He was proceeding under 2, which is a short notice provision, and he was terminating by that, not by forfeiture. And that's what's rejected by the Court of Appeal at 850F to G. They say there's no logical reason to treat 1 and 2 differently. And then at 850H, they point out that the landlord construction lets him avoid the protections that come with forfeiture. And avoiding the protections that come with forfeiture is a feature which goes against the landlord, which is perhaps relevant to my ground 1 more than my ground 2. So Richard Clark and Widnall is a case about its context. It's a case about a particular form of tenancy that was being determined in a particular way. It's not authority for the proposition that having a right to seek possession is forfeiture. Might I just have 1 minute with Miss Robbins? Unless I can be of any further
Thank you very much, Mr.
Thank you very much.
Yes.
Thank you, Madam Chair. First of all, can I just pick up the point about the Protection from Eviction Act 1977? When I mentioned it in my opening, I did so for historic background, and of course I accept that it does not protect the tenant from termination of the tenancy, but purely from physical protection from Eviction Act, not protection from Termination Act. So if I can make that clear.
That's very kind of you. Thank you. Perhaps I could just make clear also that I had another quick glance at the Law Commission's report on forfeiture, and it is in fact 1985, not earlier than 1985. So that's a point I made before.
Oh, yes, right.
A correction I thought I would make, Mike.
I see my lady has the full text of the report.
No, I have the text of termination of tenancies, number 221, which is the 1985 report, whereas you've got the 2006 report.
I think I did mention there were 2 reports.
But this is the one which is really...
Well,
It's also got a very good description of forfeiture in the back, if anyone's interested.
I think we looked at it in the course of the preparation, but thought for economy we'll put the later one, and we put an excerpt from that, but the lady characteristically is well ahead of me and sees that, has seen that. Thank you very much. Can we just stand back to the 2 issues? The first issue on ground 1, I characterised it as limb 1 and limb 2. Limb 1 is what is meant by subject to termination by the landlord, and the principal submission that I urged on the court, which found favour in the Court of Appeal, is beside the language of the section, if you don't gather up all the contractual rights, you leave a gaping hole for the landlord to avoid security of tenure by lawful means. It would be perfectly... Look, this is a scheme which preserves the contract, but with statutory incidents. So there's freedom of contract here, and there's nothing to stop the landlord, a well-advised local authority landlord, or other public sector landlord, could say in those circumstances, well, we'll give fixed-term tenancies, we'll write in a general break clause or provision, and we won't have security of tenure. And that's, with respect, that's simply an unacceptable reading. Nothing, in my respectful submission, can force that sort of reading. So we go into the second limb of ground 1 on the basis that this is a section which brings within it all the landlord's contractual rights. And that also gives content, we say, to our case on the second limb of ground one, that is to say whether the landlord is forced in every case to go through this quasi-forfeiture procedure. And the court already has our submissions on that. That's an untenable reading. And that begs the question, which has been debated with my friend, about the relationship between forfeiture and the statutory grounds. And having respectfully warned the court, cautioned the court against a liberal interpretation of a forfeiture clause, my friend is, with respect, inviting it now to take a step change in relation to default. Default is the very essence of forfeiture. Every member of this court is familiar with the terms of Section 146 of the Law Property Act. The first section of that Act mentions breach 7 times. I respectfully take my Lord Briggs' point about the idea of serving a 146 notice on a redevelopment break clause or something. It simply doesn't make any sense. Not at all. How can you say, how could a local authority say we need to demolish this block because it's about to fall down and people are in danger? And here's a 146 notice, so you can go to the county court and apply for relief from forfeiture. I'm not seeking to be frivolous. This is a very, very serious point. It goes to the heart of my friend's case on the second limb of ground one. And so it's impossible, we say, to stretch the law of forfeiture. Beyond that, my Lord Briggs described it as security for performance, and respectfully agree. That's what it's about. That's why, historically, and this goes back a long, long time, we have an early case in the bundle which mentions it, which is why personal bankruptcy or insolvency or whatever has always been a ground, long been a ground for forfeiture. It's well established. But to take that principle further is simply more than this legislation, and it would have serious consequences for local authority, in particular, management of housing stock. And as Lord Stevens said, quite rightly in my respectful submission, this is legislation not just about landlord and tenant rights, it's about social policy, social housing, and that should be taken into account. My friend made, if I could just pick up just a few loose points, in terms of the status of the two statutory instruments. My friend made the point that Parliament had endorsed the earlier SI when it passed the Housing Consequential Provisions Act 1985. In my respectful submission, I think that's overreading it. All that was is a continuity provision, and I don't think it can be sustain the argument that Parliament should be taken to have scrutinised that SI at that time and somehow endorsed it. There is a problem with the SI 526. I've alluded to this in my opening. If we could just go to that 526. Now, a headline submission on the statutory instruments is that they can only be taken so far in terms of as an interpretive aid. And I think Lord Scott has said something to that effect, and it's in the printed case. But if we just look at 526, and this is being put forward against us as an interpretive aid, as a way of reading the legislation. We just look at subpara 2, 2.2, or 2 subpara 2. And this is in relation to fixed-term tenancies. The notice to be served on a secure tenant under Section 33 before the court can entertain proceedings for the termination of a secure tenancy, which is a tenancy for a term certain, and for possession of the dwelling house let under that tenancy, shall be in the form specified in Part 2. Now, the Secretaries of State are not to be taken to use loose language, but that tenancy seems to suggest a tenancy for a term certain. Well, the possession order would be a tenancy under Section 86, or what is now 86. And that is either the Secretary of State thinks there that you can get a possession order of a fixed term tenancy, or it's an error.
Well,
so
it was originally let under that tenancy. The property, doesn't it just mean, and then go and get a possession order for a house that was originally let under the fixed term tenancy?
Well, it may be that's a way of reading it, yes, but this is, I'm not being critical of the Secretary of State's draft, but this has been put against us as an interpretive aid to reading the section. And we say respectfully that it simply doesn't support that. My friend made a point about demotion orders. I think the Lord Stevens has seen the problem with that because Section 82, capital A, subpara 6, says that these apply to fixed term as well as periodic tenancies. So we do have, on my friend's case, this rather odd situation where you can go into one part of the list as a fixed term landlord, you can go into termination, you can go into another part of the list, demotion, but you can't go into the third part of the list. And when one looks, and the Lord Legatus has already said this, when one looks at the structure of the section this court is construing, Section 82, we have the language of a list. When you've got a section which starts off may, and then 1, 2, 3, joined by an or, that's the language of election. So on any plain reading, we say respectfully, and we respectfully adopt Lord Stevens' reading of Section 32, we say it's clear on 32, but if it's not clear on 32, it's certainly clear on 82. The landlord whose tenancy is subject to termination by the landlord can elect from that list. Possession order, termination order where they want to forfeit, or demotion order. It's clear as day, we say.
Just going back to your last point, sorry, quickly. If you have got the problem that you have a right of forfeiture and you're the local authority wanting to claim possession, you can elect then. It's either 1A or Section 146. In the way that it's brought into Section 82. There are two limbs.
There are two limbs.
Straight under 1A.
Of course, my lady, yes. I mean, it may be. I mean, if I may be permitted to say, this will be no surprise, local authorities would not want to forfeit if they could deal with it in a different way. It's not the way that they would wish to treat their tenants.
Well, but in any event, the subsection says, subsection 3, where you're seeking possession in pursuance of that provision, i.e. in pursuance of the forfeiture provision.
Emphasise that.
Yes.
As we did below. Again, that's the language of election. Yes, I mean, it may be that it's in the local authority's interests to forfeit, say, in a rent arrears case. Why? Because if you look at the County Courts Act provision on forfeiture, the precondition to relief is payment in, or payment to the landlord of the full amount and costs. Yeah. Whereas if you go for a possession order, you might not even get an order. It could be adjourned, it could be stayed, it could be suspended. And typically, the arrears will be paid by instalments. So there could be a tactical advantage to local authorities, but I dare say that they would not want to go down that route unless they were absolutely forced to do so, because it's not the way they want to treat their tenants. Which does beg the question in this case, what really is the interplay between forfeiture and modern social housing management? And the court already has my submissions that there is a historical context to forfeiture. It's relevant that the original Act was retrospective. It had to catch tenancies, fixed-term tenancies with forfeiture clauses in them. We're not, for our part, we're certainly not inviting this court to construe the London Borough of Wandsworth's tenancy conditions, but that's just an example, and they may or may not be lawful. It doesn't really exist.
You're saying the Act shouldn't be construed as seeking to promote forfeiture as the way you have to go in all
We say that,
these circumstances,
Yes.
and have clauses which refer to re-entry and forfeiture, instead of something which just refers to the Act, like your clause.
Yes.
But it is inherent in your submission that local authorities are quite happy to treat their tenants by, on a Monday, granting them a 21-year lease, and on a Tuesday exit, saying, oh, by the way, we're going to seek possession on redevelopment grounds.
Well, I wouldn't say happy, but that's the scheme. That is the scheme. That's part of the security. That's the quid pro quo for security. Again, we go back to green paper.
It would be extraordinarily unreasonable for somebody to act in that way.
Yes.
And so the only one that you'd get home on would be 9, or the only ones would be 9, 10, and 11.
Yeah.
Any other one, it would be absolutely invidious of any of a local authority to act in that way. Not unreasonable, but you could imagine other pejorative terms to apply.
Oh dear.
Yeah, so you wouldn't get possession.
Lord, the court has our submissions on ground two, short point on ground two. I don't think I can really say anything by way. Can I just have a moment, please? Okay. Lord, thank you very much. There are just two matters, I think, finally for me to deal with. Firstly, costs, Rule 47. Can I please invite the court to make the usual order and to defer submissions until judgment?
Yes.
And secondly, Mr. Kasbar has, I think, compiled an email picking up the various bits that we have agreed to do during the course of the hearing, which, has it gone?
No, it hasn't gone yet. I'm just waiting for approval from the appellant.
Don't worry. It's better if you get it approved first. That's the list of grounds, isn't it?
The list of grounds and the documents that my lady.
Yes. Thank you. Thank you.
Including the eBay copy of the green paper.
My friends now address the Supreme Court. And I shall leave the green paper with the library as well.
Thank you.
But those are our submissions in
Thank you very much. Well, we're grateful to both of you, and indeed to your supporting teams, for the well-researched and interesting arguments that have been presented. You've given us a lot to think about, and we will go away and do so, and let you have a judgment as soon as we can.